So, ladies and gentlemen, we are going to start the second plenary session. So, once again, to those of you who are still outside of the ballroom, to please enter the ballroom because we are going to start the second plenary session.
Ya, Bapak Ibu yang masih berada di luar, kami persilakan untuk masuk ke dalam ballroom karena acara akan dilanjutkan dengan plenary session 2. Ladies and gentlemen, thank you for coming back to the ballroom. The next agenda is plenary session 2, which Mrs. Dr. Sri Wahyu Handayani SHMH will moderate.
But before that, we'd like to read the curriculum vitae of Mrs. Dr. Sri Wahyu Handayani SHMH. Mrs. Dr. Sri Wahyu is currently in charge as the Secretary of Institute of Research and Community Service of Jenderal Soedirman University. She did her bachelor and also her master degree at the Faculty of Law of Jenderal Soedirman University and doctoral program from the University of Indonesia. And her field of expertise are in agrarian law and also administrative law.
To Mrs. Dr. Sri Wahyu Handayani, the floor is yours.
Okay, thank you Ms. Eni Andreas. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Okay, good afternoon ladies and gentlemen, good afternoon distinguished speakers and also the participants. Welcome back to this conference room and thank you for staying with us, and I hope you had a wonderful lunch and also a short break after the first session in this morning. Okay, and I will greet the participants who are online to the Zoom meeting. Hello, the participants in the Zoom meeting, are you still with us? Okay, thank you. I see there are some participants over there. Ladies and gentlemen, at the moment, I'm honorable to be moderator in this session. And in this session, we have 3 speakers, and they will share their knowledge to us. And after that, I will welcome all of you to ask some questions to the speaker and also give comments to their presentation. And I will give chance to the participant in this room and also the participant in Zoom meeting. And the session will last for 2 hours, 60 minutes for presentation and 60 minutes for panel discussion. So I hope we can wrap up in 3 p.m. And ladies and gentlemen, now let me to address our first speaker, Profesor Dr. I Gusti Ayu Ketutrahmi Handayani SHMH, the Dean of Faculty of Law Universitas 11 Maret. Prof. Ayu will join us through online via Zoom meeting. I will greet Prof. Ayu. Hello, Prof. Ayu. Good afternoon.
Afternoon.
Okay, how are you today?
I'm fine.
Okay, thank you very much for staying with us. And the second speaker is Professor Nurul Barizah, SILM, PhD, the head of Quality and Assurance Board, Universitas Airlangga. Prof. Nurul join us through Zoom platform. I will greet Prof. Nurul. Hello, Prof. Nurul. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh.
Okay, thank you very much. How are you today?
Ibu Dr. Sri Wahyuni.
Okay, nice to see you. Nice to meet you via Zoom online. Okay, thank you for staying with us in this room. Okay, and now, the last but not least, the third speaker, Associate Professor Christopher M. Kaysen, GDLM from University of Washington. Mr. Kaysen, please kindly join me on the stage. Applause to Mr. Kaysen. Because he is the only one, the speaker, who stays in this room. Please. Okay, ladies and gentlemen, we cannot wait to learn more from the speaker. And without further ado, we will start our session today with Prof. Ayu as first speaker. Prof. Ayu, hello Prof. Ayu. Are you ready to become the first speaker? Hello, Prof. Ayu. Could you hear me clearly?
Hello.
Yeah, hello, Prof. Ayu. You will be the first speaker in the session. Are you ready?
Yeah.
Okay, okay. Before that, I would like to give brief introduction about Prof. Ayu. Prof. Ayu was born in Jakarta on October 8, 1972, has been Professor of State Administrative Law since 2016, and has served as Dean of the Faculty of Law from 2019 until now. And she has two children, a son and a daughter. Prof. Ayu has bachelor degrees from Universitas 11 Maret Surakarta, master's degree and doctoral program from Gajah Mada University, Yogyakarta. She's also joined sandwich program at National University of Singapore. Prof. Ayu also gained intellectual property rights in 2022, including digital water quality measurements, water quality monitoring and distribution method based on EOT, digital water measurements. And Prof. Ayu will deliver her presentation entitled Reconstruction Model for Geothermal Utilization Regulation in Conservation Forest Areas, Emphasis on Meaningful Participation to Realize Community Independence in the Energy I am processed in East Nusa Tenggara and South Sumatra Province. Okay, let's give our warm welcome to Prof. Ayu. Prof. Ayu, the time is yours for 20 minutes.
Okay, thank you. Can you hear me?
Yes, Prof.
Hello, Ibu. Good evening.
Yes, good evening. Good afternoon, Prof. Ayu. Yes, we can hear you clearly.
Yeah. Did you see my presentation? I already.
Yes, we are ready. Okay, PPT, please, a technician, help us to show her presentation.
Maybe could you help me share the presentation? I already started.
Technician, what's the problem? Oh, signal. Hello, Prof. Ayu.
Yeah.
Yeah.
Share point.
Yes, technician, please help to share the presentation.
Mungkin bisa dibantu sana.
Mas Ali, bisa share? Oke, sudah share. Okay, Prof. Ayu, PPT is ready. You can start it. Prof. Ayu? Yes, Prof. Ayu, can you hear me?
Yeah.
Okay.
Yeah. Could I start?
Yes.
Thank you very much. Assalamualaikum. Good afternoon, ladies and honorable of law, Universitas Jenderal, my colleague, Sir Fauzan, the honorable doctor, my colleague Professor from Universitas Erlangga Surabaya, and occasion, see you again. I hope you remember UNS. And the honorable all participants, the third ICOLGAS, and ladies and gentlemen, good afternoon. Please let me share my station research about our research funding Ministry of the Republic. Please, can you hear me? Maybe jaringan. Yeah, you can hear me? Yeah, my topic is reconstruction model for geothermal utilization, regulation and conservation forest areas based on meaningful participation to realize community independence in energy transition process, especially East Nusa Tenggara and South Sumatra province. Ladies and gentlemen, we can see about our policy, our energy transition policy in Indonesia, which is we have the transition to carbon neutral until 2060. The first timeline for strategic achievements in achieving net zero emissions in the energy sector. We have 2025 reduced emission of 196 and 98 million tons of CO2. And then 2035, we reduce emission of 275 million tons of CO2. And the last, our policy, we have 2050, in 2050, reduce emission of 956 million tons of CO2. So, this is the roadmap will be a form of joint commitment between the government stakeholders. Net zero emission in 2060. But we hope before 2060 we can net zero emission too. This data from Directorate Jenderal EBTKE, Ministry of Energy 2022. This is the map, the energy and many kind energy resource availability in Indonesia. We know we have many natural resources and mega biodiversity. And the energy resources available in Indonesia, there are biomass, marine water, coal, oil and natural gas, geothermal, etc. And we talk about geothermal energy, one of the clean energy. Many locations in Indonesia, we have potential geothermal energy. Ladies and gentlemen, we know that National General Energy have a plan target. In 20 realization in 2018, we have 8.35. You know, National Energy Plan target, and the 2025 we have increased target is 23%, and the last before 2060, especially 2050, we have 1%. The source data from National Energy Council and Pusat Data Informasi. And our legal basis, we talk about natural resources, and clean energy, especially geothermal energy, we have some basis. The first is 1945 Constitution of the Republic of Indonesia. The second is number 23 of 2014 concerning regional government. And the third, law number 21 of 2014 concerning geothermal energy. And law number 6 of 2023. The fourth is government regulation number 28 of 2016 concerning the amount and procedures for providing geothermal production bonus. And the fifth is government regulation number 7 of 2017 concerning geothermal energy, especially for indirect use. And the last is Ministry of Energy and Mineral Resources Regulation number 23 of 2017 concerning procedures for counseling, reporting, and reporting geothermal production bonuses. Ladies and gentlemen, this is a map of geothermal potential. We have in the area in Indonesia almost 13 areas. Many have potential geothermal energy. And today, our research group in Administrative Law and Energy Research Group in Faculty of Law, Universitas Belajar, my institution, we have one research in geothermal, and we have some research in energy like water, geothermal, forestry, etc. But today we talk about geothermal potential energy. Especially in East Nusa Tenggara, we have 1,188.5 megawatt in huge potential in the world. And we have some location to our research in Sumatra, especially South Sumatra in the second year. Our research is multi-year research, and this is the first, our group research years, the first years. And total resources in Indonesia, 23.76, 5.5 megawatt, and installed capacity still small, 2.130.7 megawatt. Ladies and gentlemen, this is one of location that our group research visit in geothermal development in NTT in the first year research. PLT Desa Wewo, Kabupaten Manggarai. This is the geothermal potential in East Nusa Tenggara. You know, there are 28 location of work area potential, and operating or existing geothermal potential in East Nusa Tenggara still small. You can see this data, the existing and operating still two locations, Ulumbu Manggarai and Korea, and we have some data, still initial preliminary survey, then detailed survey, and I think many and preliminary survey. And this is one map, Kementerian SDM or Ministry of Energy. This is from Pertamina, especially Pertamina Thermal Energy. Geothermal that has been utilized, Pertamina manage 13 geothermal working areas with 672 total installed operation power capacity megawatt, and 80% of total Indonesia geothermal installed capacity are within Pertamina Geothermal Energy or PGE working area. You can see some working area in this map. Kamboja is the best practice and lesson learned in Indonesia. Now, in the best geothermal in the world is in Italia. And then the second, we have Lahendo. And then the third one, Ibayak, Karaha, and then the last is Umut Balai Sat. This is the data from Pertamina Geothermal Energy or ladies and gentlemen, we know that energy is included clean energy according to Article 1 number 21 of 2014 concerning geothermal energy. Geothermal is a source of heat energy contained in water, vapor, and rocks, along with associated minerals and gases, which are genetically or transferable in a geothermal system. And for its utilization, it requires mining processes. And geothermal is non-oil primary energy that is renewable and environmentally friendly energy, and of course, clean energy. It is known from the low potential for exhaust gas emission, the small potential for gateway waste, hazardous and toxic materials, and development land, as it worry the surrounding environment for Pertamina. And then utilizing geothermal energy will be an excellent alternative in the future. So if now we can make maximum use of it, and we have many potential area in Indonesia. And the fossil energy we usually use is decreasing, damaging the environment significantly, as the gas emission release can deplete the ozone layer. And the enormous influence of fossil energy has impacted global warming due to the increasingly thinning ozone layer. So, therefore, geothermal energy as an alternative must start now. And the first important thing that geothermal energy is a clean energy, one of the alternative energy. And we must preparation to face the immense possibility of exhaustion of fossil energy resources in the world. And we know the fossil energy more decrease year per year. This is the utilization of geothermal energy. We talk about Indonesia, especially Nusa Tenggara and Sumatra. In Indonesia, geothermal energy has around 40% of the total reserve in the world. 40% is the amount, I think, the huge amount for this potential energy. Only about 2.4% of them have been explored and produced, and still small from 40%. So we have more potential to push this energy. Geothermal energy as a power generator has long been known, but not optimized now. If optimized, our dependence on oil mainly obtained from import will save countries' foreign exchange. And we can also improve the country's economy if we can optimize the use of geothermal energy, which is very large in our country, Indonesia. And apart from that, the environment in our country will be better, will be clean. And if we can reduce our dependence on fossil energy, oil and gas, which produce high pollution. This is some advantages: geothermal energy, clean, environmentally friendly, renewable energy, and then give what we call not only environmental justice, but give ecological justice. It doesn't depend on weather, supplier, availability of transportation, and loading and unloading facilities in fuel supply. It doesn't depend on the increase in the oil prices, which can change anytime. And then the last can operate continuously, sustainability environment while carrying primary loads. And this is the benefit of developing geothermal power plant. Generates electricity, very huge, generating regional income, encourage infrastructure development, improve the economy, open job opportunities, tourism added value, and so transfer of science and technology development community community. And this is state revenue, central and regional from geothermal energy. We have some what we call state revenue, central and regional from geothermal development consists of PNBP and production bonus. And this is divided into the center, producing province and producing region, and can make bonus, production bonus are given to producing region. And we know now there are programs, Flores Geothermal Island, program Flores Geothermal Island, in accordance with Article 6 of Law number 30 of 1909 concerning electricity, primary energy sources must be used by prioritizing new and renewable energy sources. So this is the best choices, I think. But we must push and make all of stakeholder what we call safe, and through the people make safe. And the following Article 11, Paragraph 1, Government Regulation number 79 of 2014 concerning National Energy Policy, Energy Development Priorities, Local Energy Resources. And with great potential and to fulfill the statutory mandate as renewable energy and local energy resources in Flores, geothermal is a priority for developing energy sources in Flores. And we know to realize geothermal energy as the primary energy source for generating electricity in Flores through the decree of the Ministry of Energy and Mineral Resources number 2268 K30 MEM to 2017. Flores Island was designed as a geothermal island called Flores Geothermal Island. And the advantages of the geothermal energy as the primary energy source for generating electricity in Flores. Ladies and gentlemen, if we can push the one of the potential energy in all of kind of energy in Indonesia, include the geothermal energy and all of the natural energy, I think public participation is the one important things to a good implementation regulation. I mean, good norm and good process for the regulation. Absolutely, public participation is an important thing. So in the law number 6 of 2023, this is the important thing in public participation is the meaningful participation must cover to implement it all of regulation in geothermal energy implementation in all of areas in Indonesia, include Nusa Tenggara and Sumatra. And law number 6 of 2023, there are 3 rights in this regulation: right to have his opinion heard, right to be considered, and the last, the right to obtain an explanation or answer to the opinion given. And we know from Zeri Einstein, public participation, there are 8 layers from the basic or the first layer is manipulation, and then the second is therapy, and of 2 of this layer, manipulation and therapy, this is the meanings of non-participation. And the third, fourth, and fifth layer, informing, consultation, and placation, this is the layer that degrees of tokenism or pseudo participation, pseudo or degrees of tokenism. And we hope our research give advice or recommendation. The best implementation in the policy, if we will push the geothermal energy to best choices, minimum the government and the people and also stakeholder can good participation, minimum in partnership, and better if delegated power and also citizen control can implement it. This is degrees of citizen power, partnership, delegated power, and citizen control. This is in the use of natural resources, at least at the partnership level. And this is legal issues in this what we call empowering geothermal energy, community, government, company, and community. In geothermal utilization, we can see Article 33 of the 1945 Constitution or Indonesian Constitution. There are distribution of benefits, and then participation, recognition of customer rights, and so also ecological justice. If we talk about the theory of ecological justice from Brian Baxter, from the books Brian Baxter, the title, the theoretical of ecological justice, justice for not only human beings, people, and then what we call many trees, and then animals, and then the ecosystem, I think. And we can see distribution of production bonus to region and fair allocation to producing communities. And the government, we also in our research evaluation, the government regulation number 28 of 2016 concerning the amount and procedures for providing geothermal production bonuses. It needs to be determined by government regulation regarding the allocation of bonuses given in local area and central area, especially section 2 and 3. This is our evidence, our visit in discussion with the regional secretary of East Nusa Tenggara Province, and then discussion with the chair and deputy chair of the regional peoples of Representative Council of East Nusa Tenggara Province, and discussion with region of Manggarai Regency, deputy chair of the regional peoples, Representative Council of the Manggarai Regency, and also we can do focus group discussion with friend from university and then NGO and the people. I think that's all my presentation. Thank you very much.
Thank you very much, Prof. Ayu. It's very impressive presentation about her research in East Nusa Tenggara and South Sumatra province. Prof. Ayu gives us issue about benefit of developing the geothermal power plant and also distribution of production bonus in region and allocation for producing communities, public participation, recognition of customary rights, and also ecological justice. Okay, ladies and gentlemen, if you have any question through Prof. Ayu, please kindly be patient because we will have Q&A panel after the presentation all the speakers. Okay, ladies and gentlemen, now we will move to our second speaker, Professor Nurul Bariza from Universitas Airlangga. Professor Nurul, are you still joining us? Hello, Prof. Nurul. Hello, Prof. Nurul. Are you still joining us? Technician, can you help me?
Can you hear me? I hear
Yeah,
you.
Prof.
Can you hear
Nurul,
me?
please turn on your microphone. Okay. Could you hear me clearly, Prof. Nurul?
I hear very clear.
Okay, thank you very much.
Can you hear me?
Yes, we hear you. Okay.
Okay, so I'm going to share.
Okay, are you ready, Professor? Okay, before
Yes.
that, allow me to read the short curriculum vitae of Professor Nurul Bariza. She is a professor of international law and the head of Quality Assurance Board, University Airlangga. She is married and he has 3 wonderful children. For her education background, she earned her Bachelor of Law, majoring in International Law in Universitas Airlangga, 1994. Then Master of Laws in Faculty of Law, University of Technology, Sydney, majoring in International Intellectual Property. And earned her PhD in Laws, Faculty of Laws, University of Technology, Sydney. Her dissertation entitled International Intellectual Property and Biological Resources. Prof. Nurul was the former Dean and Vice Dean for Academic Affairs, Faculty of Law, Universitas Airlangga. She is the member of Academic Board's National Academy of Professional Studies, Sydney, Australia, 2019 until now, and the member of Supervisory Board of the Surabaya Drinking Water Company, or PDAM Surya Sembada Surabaya, 2021 until now. She is also a country expert or assessor of International Accreditation, FIBA, Germany, 2021 until now. She has multiple publications, but the latest one is published in Journal of Intellectual Property Law and Practice 2021, entitled Plant Variety Protection Law and Farmers' Rights to Save, Exchange, and Breed Seeds, the Case of Indonesia. Prof. Nurul will present her paper entitled The Challenges for the Protection of Intellectual Property Rights of Indigenous Peoples' Works under International and National Laws. Let's give our warm welcome to Prof. Nurul. Prof. Nurul, the time is yours for 20 minutes.
Thank you very much to Dr. Sri Wahyu. Do you hear me?
Yes,
Okay,
we hear him
thank
clearly.
you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Speakers, my friend Professor Dr. Gusti Ayu that already presenting the paper earlier, and also my friend Professor Christopher Jason. Hello, nice to meet you again. And also all our colleagues and distinguished participants. Honestly, it is an honor for me to join and to have opportunity to be invited in this very important conference as a speaker. And thank you for Dr. Aryuni for make it very possible for me. All right, in line with the theme that given to me by the committee of the conference, I would like to move to different direction. If Professor Ayu talking about geothermal energy, so we are going to talk about the challenges for the protection of intellectual property rights of indigenous people works under international and national law. This topic is still very important topic and still relevant in today's context when we are talking about social justice issue for this conference. Although honestly that this topic has been discussed in number of forums and in number of arena since at the beginning of 2000. So let's know we are going to move what is the or who are the indigenous people before we going to talking further about the issue of this. So when we are talking about indigenous people, it can be regarded as like office people. In Australia we call it Aboriginal people, or in different countries we call it native people or autochthonous people. In this context, when we talk about indigenous people, mean that those who are culturally distinct ethnic group who are native to a particular culture. And a long time ago, in the era of colonialization, the term of indigenous was first introduced by European, and in modern context used to differentiate with the indigenous people of the American as slave from Africa. And then, what is the current context now? When we are talking about intellectual property right protection, the current context now is that we have to talk about the situation that we have to know exactly what are the indigenous people of Indonesia. As we understand that each country use different terms. Like Philippines, they use indigenous and cultural minorities. In Thailand, also use hill tribe. In India, call it by schedule caste and tribe. And in Malaysia, they call it orang asli. And in the context of Indonesia, the meaning of indigenous people is mean tribe group, tribal communities, or other communities. And you know that in Indonesia right now, it is estimated that 50 until 70 million other community live in our country now, and it accounts 18% of the Indonesian population. So let's move to the current context. Why this issue is very important, and why we're going to discuss today. You know that there is at the international level and international level as well, there is awareness of the importance of indigenous culture and indigenous traditional knowledge. But at the same time, indigenous people must fight harder to protect their culture and traditional knowledge from the number of threats and challenges. Why? Because, you know, there is a number of international treaty, there is a threat of globalization, liberalization of international trade with the stronger IPR protection, and the my problem is that when we talk about protection of intellectual property rights, and it's connected with the characteristic of traditional knowledge and traditional cultural expression, it seems very difficult for such knowledge and cultural expression to be protected under that conventional regime of intellectual property. The character, as I show you in this screen, that it handed down from generation to generation, and also reflect community, cultural, social identity, and it is often made unknown on author is that because it's already from generation to generation, and it regarded as belong to the community under the customary law. And another problem is that such traditional knowledge is still evolving, developing, and being recreated in the community itself. Now, then sorry. And as I told you, sorry, I'm coughing. As I told you that subworks does not meet with protection of intellectual property with the notion of conventional intellectual property, as they are not novel, not inventive, not industrially applicable, and cannot be protected under patent law. And subworks also regarded as public domain, and as well as different from the context of modern intellectual property rights. When we talk about public domain, some people can use it for development of new invention, and they can be used as a basic material for modern knowledge, innovation, and invention. And also, it can be protected if in the form of traditional knowledge-based innovation, it can be protected as invention, and then it, because it's invention, so it will be protected under patent law. But the question is raised, is it fair, just, or is it ethical? Why? Because traditional knowledge and traditional cultural expression can be protected under intellectual property rights. They are regarded as intellectual property rights. But the problem is they cannot be fully protected by existing conventional IP system due to inadequacy of the system. And then it requires the adoption of the current IP form or the development of sui generis form of protection. So because of that, this can be considered unfair, and this unfairness lead to what we call the concept of what we are known with indigenous intellectual property. Because of the many claims by indigenous community over their collective of intellectual property rights to protect their specific cultural knowledge. Then the term appear under the international law, the collective rights, in which this collective right is opposite to individual rights. So after there is recognition about the right of intellectual property right of indigenous people works, whether in the form of traditional knowledge or in the form of traditional cultural expression, then also there is recognition about collective right. But do you think that the problem has been accomplished or has been settled? No, it arises also threats and challenges. The problem is still exists, since long time ago. What is that problem and what is the challenges? The first is about misappropriation of indigenous knowledge related to genetic resources, some call by pursuit. And the second is about communication of indigenous culture, and it can be used in many forms, such like tourism activities that usually it happen in many countries in the world. So, that issue lead to what we call is the question about distributive justice, because you know that many leaders in the world in 2001 during the what we call is United Nations Conference on Environment and Development raised the concern that such misappropriation use of genetic resources related to traditional knowledge, as well as what we call is biodiversity, has a problem with unfairness, and also has the problem with distributive justice. As the president of Tanzania, as I quote here, said that most of us in the developing countries find it difficult to accept the notion that biodiversity should flow freely to industrial countries, while the flow of biological products from the industrial countries is patented, expensive, and considered the private property of the firm that produced them. This reflects asymmetry and inequalities of opportunity, and this is that we call is unjust. So, how international law deal with this problem? How international law would like to answer this issue? Distinguished participant of the conference. As I told you earlier, that this problem has been discussed in a number of international fora since at the beginning of 2000 or earlier than that in 1996. Many international organizations under the umbrella of United Nations has a very significant big concern about this issue. They like to settle that problem by setting a number of forums. It's not only in the international environmental law under the CPD, Convention on Biological Diversity and Nagoya Protocol, but also in the international human rights. It is concerned about the right of indigenous people, and then also in the UNESCO, and also in the Food Treaty, International Treaty on Plant Genetic Resources for Food and Agriculture, as well as in the international IP law. So, distinguished participant of this conference, let's talk about the CBD. Under the CBD principle, it stipulates under the article earlier than Article 8G, state that Convention on Biological Diversity recognize the right of the right of traditional knowledge, or right of indigenous people on traditional knowledge. And this convention required the government to issue national law to encourage equitable sharing of benefit. Then the technical aspect of this can be seen in the Nagoya Protocol on access to genetic resources and the fair and equitable sharing of benefit from the utilization of the resources. And then after that, we can see in that Nagoya Protocol, all is, that talking about how national law should implement the benefit sharing, have to ensure that there is a parent among consent, and also there is what we call is the ownership of who hold the ownership of indigenous and traditional knowledge from the local community, and from which the consent can be get it from for its utilization. And then after Nagoya Protocol, let's move to the United Nations Declaration on the Right of Indigenous People. Distinguished participants of this conference, when we talk about United Nations Declaration on the Right of Indigenous People, one of the very important and crucial article is the Article 31, in which it states that the indigenous people have the right to maintain, control, protect, and develop their cultural heritage, traditional knowledge, and traditional cultural expression. And in this context, this declaration also recognizes that right of indigenous people is part of human rights. And from this perspective, then, from this United Nations Declaration of the Right of Indigenous People, then make UNESCO and other international organizations have a strong willingness on how to regulate and how to respond the principle that has already set up in the United Nations Declaration on the Right of Indigenous People. And then it brings us to the UNESCO, in this UNESCO is talking about what we call is UNESCO is talking about tangible and intangible property, and then we can move to the what is WIPO going to do to deal with this issue. From the screen, you can see from the WIPO perspective, what is the term given to traditional knowledge. Many name of it, yeah. So we can choose which one that is appropriate and suitable for our context. And then, as I told earlier, that many United Nations agency also has concern about this issue. And one of the important thing of the WIPO work is that the establishment of the Intergovernmental Committee on Genetic Resources, Traditional Knowledge, and Folklore. It was established in 2001, but the mandate is still exists until now. However, even it has been established in 2021, but until now, there is no significant achievement that has been achieved by this forum. The idea earlier is that WIPO should establish internationally legal binding instrument to settle this issue. But in the last session, last month, on September 8th, there has been international development for this forum, because this forum can propose international legal instrument on intellectual property, genetic resources, traditional knowledge, and related to genetic resources. And the draft proposal on international legal instrument is supposed to be concluded no later than 2024, next year. Hopefully that no later than next year, but I don't think it will be no later than 2024. And then I saw this is the draft that has been prepared by the WIPO that I already told earlier. And then, but as I told you earlier, that the approach that has been set up by WIPO since 2001 until now is still the same. That WIPO tried to settle the problem by establishing international obligation to require disclosure of origin of genetic resources used in the crime invention, and also try to promote coherent implementation of international obligation under the CPD and Nagoya Protocol. But there is a still issue that still exists until now, in which recognition of the right of indigenous and local community on the basis of human rights law and customary law is still, in pending question. And WIPO also already set up consolidated draft article, as I already show you, but the clear option for the approach to protection still in the context of defensive or disclosure requirement or offensive positive protection through existing intellectual property tool or developing a switching system for protection. So let's move to the national context now. When we are talking about national context, we cannot ignore our constitution on how our constitution recognizes our adat community in the amendment of 1945 constitution, in which the constitution affirmed the state recognition of the existence of the adat people. It's stipulated in the Article 18B, Paragraph 2, Article 20X1, Paragraph 3, and also Article 32, Paragraph 1 and 2. And what is the realization of this? Until now, based on the several research conducted, and I searching in the journal, that recognition and respect for other community are still far below expectation. Although Indonesia is signatory to United Nations Declaration on the Right of Indigenous People, but it seems that the concept of indigenous people is not applicable to the country. Probably the government regards that how to differentiate the indigenous and non-indigenous people is not known under Indonesian, what we call is concept. They talk about probably different context. Yeah, that's only 2 minutes more. Going to finish. Yeah, and then according to the report from United Nations Committee on the Racial Discrimination, it said that Indonesia is not respecting the principle of indigenous self-identification, and also when we talk about ILO Convention 169, the Indigenous and Tribal People Convention, it provides guidance on the right of indigenous people self-determination, but Indonesia has not ratified this treaty until now. So let's move to the how national IP law deal with this issue. There is two laws that deal with the issue. Also, some of the work of indigenous people can be protected under different IP law, like trade secret or geographical indication. But for the traditional cultural expression, we can see in the Article 31 of copyrights, in the state obligated to inventory and preserve traditional cultural expression. And then the use of traditional cultural expression must pay attention to the value that live in the community where they are held. And then from that copyright law, the government issue regulation number 56, 2022 on the communal IP. In this, there is a need for documentation of the traditional cultural expression and traditional knowledge in Indonesia. And then let's move to the national IP law in the context of patent law. In the context of patent law, the law already stipulates defensive protection through disclosure of the source of origin in the Article 26. The law also set up the criteria for prior art, including orally expressed, and also disclosure of requirement to implement the CPD principle and Article 29 of TRIP agreement. But the challenges is that no legal sanction for the filer to disclose. And the challenges also is that no permission required for the owner of genetic resources traditional knowledge for its use in the invention. And in addition to that, patent, finish, last one. And patent can be removed if does not meet the criteria of the Article 26 regarding the disclosure based on the third-party plan. And the last thing, this last PPT, another biggest challenges that they are facing today in Indonesia under national law, when that was stipulated that the inclusion of that disclosure of origin is to promote fair and equitable benefit sharing as stipulated under convention like CBD, Nagoya, International Treaty on Parent Resources. But until now, there is no such type of fair and equitable benefit sharing has been implemented. And another challenge is that when we are talking about fair and equitable benefit sharing, it seems like we are looking for charity. But this concept is not charity concept. This concept has been set up by international law that the distribution of fair and equitable sharing should be given to the resources country of the genetic resources related to traditionally in which they derive from. And the last thing that I quote the what we call is the statement from Prime Minister of Malaysia that we should treat different country, different people equally, and shall not be exploit each other. Thank you very much.
Tribal communities or adat communities. Indonesia is home to an estimated 50 to 70 million indigenous people, or 18% to 19% of the Indonesian population. And there is awareness of the importance of indigenous culture and indigenous traditional knowledge at the national and international level. But at the same time, indigenous peoples must fight harder to protect their culture and traditional knowledge from a number of threats and challenges. They need an umbrella legal term used in national and international forums to identify indigenous peoples. Prof. Nurul has explained about the development of international law through international forums such as International Environmental Law, Nagoya Protocol, International Human Rights, UNESCO Convention on Cultural Heritage, and also International IP Law YPO. Okay, ladies and gentlemen, if you have any questions, so please be patient because we will have Q&A panel after all the speakers deliver their presentation. And now we will move to the third speaker, Mr. Christopher Kazan from University of Washington. And Mr. Kazan, thank you for being here today because you are the only one speaker who's staying with us in this room. Okay, before his presentation, I would like to read his curriculum vitae. Mr. Christopher Kazan completed his Master of Laws, LLM International Dispute Resolution at the University of Miami School of Law in 2019. He is currently a senior lecturer at Univeritas Indonesia, Yogyakarta, and he has a vast professional experience, including senior consultant at PT Blue Vision Consulting Jakarta, international business law lecturer at Gangwon University in South Korea, and attorney at law in Washington, USA. He has multiple publications. The latest one is the Regulation of Defendants' Religious Identity in Court Decision, Bestur 2022. His professional highlights include first, volunteer ESL instructor for orphanages in Jakarta and Yogyakarta, Indonesia, and Daegu, South Korea. And second, recognized as a rising star in Washington's Best Lawyers edition of Washington Law and Politics. Wow. Okay, third, Procurement and Development Committee member for Keystone Auction for Civil Works. And in this session, Mr. Christopher will deliver his presentation entitled Protection of Indigenous People's Rights. Let's give our warmest welcome to Christopher Carson. Professor, the floor is yours for 20 minutes.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Namo Buddhaya, salam kebajikan. So, good afternoon. Thank you, all of you, for being here. Thank you to the committee, ICOLGAS committee, for inviting me here. Thank you to Pak Rector and Pak Dekan. And thank you for all, Mbak Ayu, for all of your hospitality and welcoming me to Purwokerto for the first time. I appreciate all of the participants who are here, as well as the participants who are online and unable to join us here today. So, can I get the presentation, please? Thank you. We'll see if this works. Sort of? Okay. So, I'd like to start off with a brief introduction of why, about indigenous rights, particularly in the United States. Okay? And recently, there was a case that was decided, or settled more accurately, dealing with indigenous fishing rights. So the Native American rights to fishing. And even though it doesn't seem like a significant case by itself, it highlights the history and the legal relationship between Native Americans and the United States government. And it also brings into focus some of the conflicts that happen between environmental interests, sustainability interests, and indigenous peoples' interests. And so we'll talk a little bit about the history and the law in the United States, and then about this case, the Sauk Seattle Indian Tribe versus Seattle. Oops. Next slide, please. Yes. Okay. So I normally don't want to talk about myself. I'm not that important. But my hometown is Seattle, Washington, in the northwest part of the United States. And the only reason that's important to this case is the city of Seattle was the defendant in this case. So this all started when one of the Indian tribes sued the city of Seattle. And of course, it brings back the very, very fraught history between the European colonists and the Native Americans. And again, the reason I put this picture of fireworks up here is there's a little story that reminds me of my childhood. Now, I know in Indonesia we celebrate Independence Day on August 17th. And it's independence from Dutch colonization. Well, in America, we celebrate Independence Day on July 4th. But it's a little different Independence Day. So it's the colonists celebrating independence from the British Empire at the time. And like many celebrations, we like to use fireworks. But this terrible thing came to my mind as I was thinking about my childhood and how much I love fireworks. I like to shoot them off here during Eid al-Fitr. I love fireworks. But then I remembered when I was growing up in my hometown, fireworks were illegal. You couldn't just go buy them in the store. So we would drive to the Indian reservation, which are lands that were set aside for our Native American population. Long story, but they could sell fireworks that were illegal outside of the reservation because they have semi-autonomy. And I thought of the irony of buying fireworks on an Indian reservation to celebrate essentially white person's independence. And it was because of that story that I thought about this sort of both unique and terrible history of our relationship with the Native American population, the indigenous population, and how that still is important today. We've been talking about indigenous people, we've been talking about sustainability from my esteemed colleagues. And so I'd like to take a little bit different angle on it. There is a sad history, thank you, sad history in the United States of this doctrine of discovery. Colonists called it discovery, and I don't think the indigenous populations felt quite the same about that. The colonists came to exploit the natural resources that were more scarce back home, and in exchange we brought disease, conflict, imposed monotheism, and some of the worst actions were the forced relocation of natives. During this process of westward expansion from the east coast of the United States to the west coast of the United States, we often forced native indigenous people from their land. And as part of that, we introduced acts of Congress in order to try to assimilate the indigenous populations into the European culture. And as you can imagine, that didn't go so well. So if you go to the next slide, please. Okay. By the way, just a quick note. May interchangeably use the words Indian or Native American, Native, and again, Indian comes from the fact that our first explorers got lost and think they landed in India rather than in what is now North America. Even the word American is Eurocentric, coming from the explorer Amerigo Vespucci from Europe. But that's sort of the names that we use both in our normal speaking and our laws. So I'll keep using those. Again, they are indigenous peoples. I think they're referred to as Aboriginal people in Australia. Sometimes they're referred to as First Nations people because the tribes were organized into nations themselves. Like Ibu Nurul mentioned about the Indonesian Constitution, the US Constitution, next slide please, sorry, does specifically mention Native Americans in the Constitution itself, again, referring to them as Indians. And what was most significant and what I think is most unique about the American system, and when I say unique, I don't mean good by any means, but it is unique in the sense that as America became the United States, the colonists and the formative government of the United States entered into treaties and treated Native American tribes as if they were foreign sovereigns. And so instead of treating them as American citizens, they were treated as separate countries. And as a result of this, negotiations with these tribes were done just as if they were a foreign country. And so in the mid-1800s, there were many, many treaties that were signed, both preserving land, reserving land for the native populations, the Indians, as well as giving certain rights to use those lands. And we'll come back to the fishing rights in just a moment. This is a brief history of the legal relationship between the 18th and 19th centuries. It's not a very pretty picture, to say the least. It mostly involved the federal government taking away rights more and more from the native populations. And into the 20th century, the next slide, I won't bore you with the entire history of Native American-U.S. relations in the hope for expediency. So in the next slide, we'll see a slightly better relationship during the 20th century. And this is where, even though there were less rights taken away, and there was greater recognition of the original treaty rights and tribal autonomy. And so laws went into place, funding went into place to support tribal autonomy, and particularly for because this is a law program, particularly for tribal courts, which operate and have a mostly independent relationship from the state and federal courts in the United States. Next slide, please. So these are basically the three principles of U.S. Native relations. One is territorial sovereignty. And I know in Indonesia they have what they call semi-autonomous regions that maintain autonomy. But again, that autonomy, as I understand it, comes from legislation derived from the original 1945 Constitution, but it's still considered part of Indonesian territory. And so this territorial sovereignty in America still recognizes tribal land as separate sovereign property. It's a sovereign within a sovereign is how it's been referred to. Again, not to bore you with United States federalism, but any dealings with Native Americans are done by our federal government and not on the state or local level. So it gives plenary power to our Congress. And third, it creates this trust relationship, meaning that the United States government is trustee of the land that's held by indigenous people. There's a number of cases, because it's a common law country. Everything is done through case law, and these are cases dealing with reaffirming Native American autonomy and this trust relationship and this treaty relationship. So basically upholding the treaty relationship as we go along. And again, my paper goes into a little more detail about the genesis of this legal relationship, but again, in 20 minutes, we don't have time for that, or 5 minutes left, we don't have time for that. So I'd like to move on to the case that sort of spawned this, it sort of is a microcosm of this relationship. But first of all, next slide, please. As discussed in Australia and Malaysia and Indonesia, water is one of the most precious resources we have on our planet. And hearing about the right to clean, accessible drinking water as a human right. In America, it also is considered one of the most precious rights, especially in the Western United States. And the Native Americans, through these treaties, have about 30% ownership of most of the water accessible in the Western United States. So these rights are very important. The other right are Native American fishing rights. Move to the next slide, please. And as you know, especially in the South China Sea, that fishing rights, dealing with Indonesia's neighbors of the Philippines and Taiwan, and Malaysia and China, that fishing rights are vitally important. Well, they're also important in the United States. And they're essential to Native American sustenance and Native American culture. And these rights are guaranteed in these treaties that were signed back in the middle of the 19th century. But there's lots of other interests too. First, there's non-natives who want to fish as well, commercial fishermen. But it also goes in conflict with conservation groups who are attempting to conserve fish populations and other and protect the natural resources. So all these interests sort of conflict when it comes to fishing rights. Again, Native American fishing rights, thank you, have been upheld over and over again. So I won't, again, bore you with the jurisprudence. So if we could move on to salmon versus hydropower. If you would go forward one more slide, please. Okay. So hydropower is generally thought of as clean energy. Okay? It's basically the river runs through a turbine and that generates electricity. And in the Northwest and a large part of the Western United States, most of the electricity generated comes from hydropower. And it's long been thought of as one of the greenest forms of energy, especially compared to burning coal, nuclear, or burning other fossil fuels. However, salmon, which there is no native salmon to Indonesia, is a unique creature. So a salmon begins its life in a freshwater river bed. Once the salmon becomes a little fish, it swims downriver into the ocean. It grows up on the shoreline and spends most of its life in salt water as an adult fish. The females then swim back to their native fishing spawning beds and lay their eggs for the next generation of salmon. So it's a unique fish, and I don't think there's anything similar, any type of fish similar in Indonesia. But salmon is very important in especially Northwestern Native American culture. I'm getting hungry right now just thinking about it. But so it's very important. It's very important commercially, but however, it's in direct conflict with this hydropower. So this green power is decimating salmon populations because the salmon can't swim upstream. If you can see one of my previous pictures, the actual dam in conflict itself, here, yes, thank you, destroy spawning areas. So if you go down to the next level, so this lawsuit was somewhat unique. Of course, the Native Americans sued the city of Seattle. The city of Seattle gets its power from this particular dam. So they sued for infringement of their treaty rights, basically violating the search and seizure amendments to the Constitution. They also sought jurisdiction of the tribal court. And third was their unique argument, and this came up earlier in our first plenary session, about the rights of non-humans and recognition of non-human rights. And what the tribe here, the Sauk Seattle tribe, said was that fish have rights to exist on par with humans. And this tribe has standing to protect the salmon populations on behalf of nature, essentially. And it was a novel argument. So, next slide, please. Essentially what happened, whoops, back one, thank you. Essentially what happened was the case settled. So unfortunately, there is no Supreme Court case that decides this. But given the legal ramifications, the city settled with the tribe. And ultimately, they're changing the structure of these dams in order to allow fish to swim downstream and swim upstream to spawn. So it's considered a major victory in balancing human interests, tribal interests, and conservation and ecological interests. However, the settlement didn't go far enough to say that salmon have rights on par with humans. So they wouldn't go that far because that would open up a number of implications that would change environmental policy. So, in conclusion, thank you. It's been a long, fraught history between the Native Americans, and no part of it is good. However, it is unique, and some of the rights that the natives have today, the indigenous people have today, come from this history and this unique situation of treaty law. Unfortunately, or as a lawyer, fortunately, because lawyers make lots of money off of lawsuits, most of enforcement of these rights has happened in the court system. It takes the tribe having to sue the city or having to sue the government in order to enforce their rights. And so while the result here was good for the fish, as one of the articles cited says, it seems a shame that it has to happen this way, and it can't happen on a more efficient, collaborative way. And so I hope that was interesting a little bit about, even though it does not affect indigenous people's rights in Indonesia or anywhere else, hopefully it gives a little insight into indigenous rights in my hometown. So thank you very much. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you very much. It was mind-blowing presentation, Mr. Kaisan. Okay, Mr. Kaisan explained about history of native United States relation, unique treaty, rights fishing stocks with Indian trip versus city of Seattle. Mr. Kaisan also explained about three native U.S. legal principles, including territorial sovereignty, trust relationship, congressional plenary power, and also fishing and riparian rights still continue to test the relationship but on 175-year-old treaties and need to do a better job of protecting the human rights of indigenous people. Okay, once more, please give applause to all the speakers. Okay, ladies and gentlemen, now this is the most awaited moment, is the Q&A panel. So I will open Q&A panel for you, the participant in this conference room, also the participant who are online in Zoom meeting. You can raise your hand, mention your name, mention your institution, and please mention who will you ask to. And also the participant in Zoom meeting, you can raise hand or you can write in the chat room. Okay, first question. Man, over there, okay, please mention your name, institution, and who will you ask? 1, 2, 3, okay.
Well, thank you, Bu Moderator, for the time, and thank you for speakers from for presentation. Well, my name is Lutfi Hafiz Rafsanjani from Law Faculty, Universitas Diponegoro, Semarang,
Okay.
and I would like to ask a question, especially for Prof. Ayu, and maybe it's question for Professor Kaisan too. Okay, in our Constitution, the 1945 of the Constitution of the Republic of Indonesia, especially in Article 33, Paragraph 3, the land, the waters, and the natural resources within shall be under the power of the state and shall be used for the greatest benefit of the people. This article in our Constitution is emphasized that the environmental resources exploitations is for fulfillment the welfare of the people or welfare state. I think this contradict with the concept of environmental justice. My question is it necessary to re-enlighten our Constitution by adopting the concept of environmental justice? Well, thank you.
Get it, Professor? Get it? Okay, thank you very much. Okay, and the next, mention your name, mention your institution, and mention who you will ask.
Okay, thank you, Bu Moderators. This is an honor for me to asking special to Prof. Ayu.
Prof. Ayu, wait a moment. Prof. Ayu, are you still joining with us?
Yeah, by incident, he's my promoter for my doctoral program in
Okay, your promoter.
Soedirman, Jenderal Soedirman University. So, yeah.
Mister, I'm so sorry. Wait. Prof. Ayu, are you still joining with us? Okay, yes. Okay, go on.
Okay, nice to meet you, Prof. Ayu. Okay. Okay, I just want to respond about the presentations from Ayu that according by the research, but I know that many plans forward, particularly for plant electricity for plant, yeah. And then according to research that any kinds of based on the power plants like coal and then diesel and also nuclear more than and many, there is a 10 and a potential damaging the ecology. And but Yeah, therefore, why the governments decide the rules that any kind of forward plants must be closed, not operate anymore, and changing to find the power plant or energy, yeah, to find another like geothermal. But when I'm heard by presentation from IU that in Flores they have priority to make a geothermal for plants. I think that is a little bit contradiction because of the weather there is not only geothermal, I think, but power plant by solar cells may be more than potential than geothermal. I not have read and hear, and then this is my questions that did you ever compare that which one is better to make geothermal or solar cell for energy or electricity for plants? Sometimes I confuse because of we have as richest countries, we have many potential resources for power plant or electricity power plants. But actually the richest country have and keep technology, so on China, but we don't have. Until now, we didn't know why government not try to push and try to make a power plant anywhere. Exactly by the facts that Indonesia as a richest country, we can find solar cell as free, I think. So the question is, from IU, in your presentations, I not, cannot define, and not cannot to compare also that solar cell as alternative energy. For me, I think that it's more potential than geothermal energy. That is. Thank you very much.
Okay, thank you very much. And the third question.
Yeah, thank you. My name is Rahma from Universitas Islam Indonesia. Hello, Pak Kris. My question will be addressed to Prof. Ayu and Pak Kris. Yeah, for my first question to Prof. Ayu, it's about, as we know that we want to balance the interest of energy conservation and also to fulfill the national determined contribution by expanded a lot of renewable energy resources, such as Prof. Ayu already presenting about the geothermal energies. Yeah, but as we know that the location of geothermal energy in Indonesia is mostly located in the conservation area, which is in the foresty conservation area. So as we also know that a lot of citizens in Indonesia also raise a protest about the establishment of those geothermal power plants. So my question is about that. Prof. Ayu also mentioned about the public participation in this context. So the exact question is how we ensure, and could you give us the exact measurement about the public participation in the context of this aspect, as we know that the determinations of the location of the geothermal mining and also to give the exploration mining, it should be based on the administrative decision. And as we know that the administrative decision is a one-sided legal action by the government. So which measure to determine the public participation to issue the keputusan tata usaha negara itself, administrative decision Those are my questions for Prof. Ayu. And for Pak Kris, as we know in Indonesia, we also have a citizen law suite, Pak Kris. Yeah, that the community on behalf of the ecological environment, we want to make sure that we have the environmental justice to our environments too. But as we know, the issue is that even though the citizen law suite was won by the community, the main issue in Indonesia is the execution of the judge's decision itself, Pak Kris. It's very contradict with your cases. It's very awesome cases you show to us. So please give a response about what happened in Indonesia to address the execution of judge court decision. Thank you, Pak Kris. Terima kasih.
Okay, thank you very much. Okay, I will give Prof. Ayu for the first turn to answer the question of the participant. Prof. Ayu, hello, Prof. Ayu. Are you ready? Okay, please turn on your microphone, Prof. Ayu. Okay, I'm so sorry, Prof. Ayu. Can you turn on your microphone? We haven't yet hear your voice. Hello, Prof. Ayu. Yes, okay.
Okay. Thank you for Pak Joni and Pak Surya and Bu Rahma for asking question, yeah, and some question for me. The first, Pak Joni from Undip, about the 1945 Constitution, especially Article 33, yeah, about the land, water, and natural resources that however the government must give environmental, not only environmental justice, I think, but also more than ecological justice. So that as I talk about this topic, this is our research in our groups, our research group, I mean, in administrative law and energy law, and the issues about ecological justice in the natural resources, especially in this research, is geothermal energy potential in two locations, Nusa Tenggara and Sumatra. Today I talk about geothermal energy, and as we know, there are many alternative energy, like Pak Surya said, that we have, Indonesia have more kind of potential energy or alternative energy, like solar cell. I agree with you, Pak Surya, yeah. But today I talk about geothermal energy. Maybe the next we want research together for solar cell. And about Pak Joni, the 1945 Constitution in Article 33, that I said that here government must make the first participation, public participation in the real implementation. As we know in Einstein theory about the participation, there are 8 layer participation, and I think today about participation in all of the policy or regulation, still second or third layer. So it's the meaning that there are no, or small participation in policy and product, what we call regulation, yeah, legal product, not only in central government, but also in local government. And this is the point, and this is very interesting. If we will, the government policy or regulation from the government can good norm and good process and good implementation also. And I agree that Pak Joni said that very interesting and very important that actually the Article 33, 1945 Constitution, our Constitution, more implement not only environmental justice but also ecological justice. So justice for human, for fauna, flora, and also for ecosystem. I think that's all. And about Pak Surya, why the government decide maybe one power plant and decide to close one power plant and open another plant? I think in that I said today I talk about the potential of one alternative energy in Indonesia. We have many kinds alternative energy. We can do to research. I think many kinds alternative energy, because fossil energy to decrease per year, yeah, fossil like oil and gas, and alternative energy is one of the solution, and this is the clean energy. I think I agree with you about solar cell, but today my research about geothermal, and our team recommendation that public participation is one of the issue about if government, if we will push the alternative energy, the government must make and firm and sure that the norm and that a good norm and good process in produce the legal product. I think that's all. And about basicing or keputusan tata usaha negara, I agree that must what we call cautionary principle in this topics, yeah. And about natural resources, so precautionary principle. This is one of the important things for government to what we call to make basicing. Yeah, I think that's all. Thank you very much.
And now, Mr. Kezen, okay, this is your turn to answer the question.
Okay, thank you very much. And I apologize to the gentleman from Undip. I forgot your name. However, I think about Ibu Ayu basically gave the same answer I would regarding the clause of Article 33 saying for the welfare of the people. I think the view of environmental justice is that a clean environment is for the benefit of people, and that it must be the broader long-term look at benefit of the people rather than a short-term economic benefit. And I believe I'm echoing my earlier speakers in that sentiment that even if it is limited to the benefit of the people, clean environment, sustainable food sources, diverse ecosystems are for the benefit of the people. And so that should be read, I would say, to as how Article 33 should be interpreted. To my learned lecturer from Universitas Islam Indonesia, two things. Just a quick note on your first question, which was addressed to Ibu Ayu. Yes, location. We have the same problem in the United States in that where it's easy to generate alternative energy is not the places where we need alternative energy. We don't have solar farms or geothermal sites near big cities. And so, I can imagine getting the power from Flores to Jakarta is very difficult logistically. And so location is one of the biggest obstacles, I think, to recognizing, to reducing emissions in generating electrical power. Regarding your second question about the effectiveness of litigation in enforcing environmental policies, I guess it would be less of an issue of, it's not particular to the environment. It's what are the power of courts to, in a system of checks and balances, what is the power of the courts over the executive branch, which both operates and enforces the law. So if a court is ineffective in having the ability to force action of the executive branch, that's definitely an issue, a constitutional issue of separation of powers. And so, is it effective? We had a lawsuit in the United States similar to that in Montana, and basically the constitutional court, similar, said this provision of the law is unconstitutional, and so it can't be enforced, and that the executive branch would be violating the constitutional rights by enforcing it. Again, I'm showing my ignorance about Indonesian law. And I don't know if there is such thing as what we call injunctive relief, where a party can be forced to actually take action instead of just damages. I'm not sure exactly what that mechanism is, but that would be, in my mind, how, the power of the courts to enforce, to give teeth to both environmental regulations and citizens' litigation for those, to enforce that legislation. So it's the independence of the judiciary, I think, is a big issue. I hope that answered your question. Thank you very much. And I think that's it.
Okay, thank you very much, Mr. Kaisan. Okay, ladies and gentlemen, there is such a wonderful discussion, but unfortunately, the time has come to end this session. So, but before that, allow me to wrap up once again our fruitful discussion today. There is still challenges for the protection of intellectual property rights of indigenous peoples' works under international and national law, and need a regulation for indigenous peoples' claims of collective intellectual property right to protect specific cultural knowledge of their groups. We need certainty of rules and implementation about indigenous people right on fishing and riparian right. The interests of cities should not violate the interests of the indigenous people, like you say. And the similar case happening also in Indonesia. Other communities as indigenous people need special regulation in national law, and also we should give attention to regulate policies regarding alternative energy for nature conservation. Okay, ladies and gentlemen, please give applause to all the speakers. And on behalf of the Faculty of Law, I would extend my deepest gratitude to all the speakers. First, Prof. Ayu, thank you very much, Prof. Ayu and Prof. Nur, who are join us online via Zoom meeting. Thank you for staying with us. And also, Mr. Kisan, thank you for being here. And thank you for your generous time and knowledge sharing that I believe discussion is nothing but insightful for all of us. And ladies and gentlemen, I hope we can see you in the next future, or in the next international conference held by Faculty of Law. And once again, thank you very much, and see you, and I will return the time to the MC. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you to Mrs. Dr. Ayu. I invite the speakers of plenary session 2 to hand over the certificate and trophy. The certificate and trophy will be given by Vice Dean Faculty of Law, Profesor Dr. Kadar Pamuji SHMH. The Honorable Professor Dr. Kadar Pamuji SHMH, please come to the stage to hand over the certificate and trophy.
Thank you very much. And to all speakers who join with us online, we are going to send all the certificates and also the trophy later on by the committee. So yeah. So ladies and gentlemen, you may have a coffee break near the entrance room. And please be ready at 3:30 p.m. waktu Indonesia bagian Barat in the room that has been plotted by the committee. And all participants are expected to return to the ballroom at 8:30 p.m. waktu Indonesia bagian Barat for the announcement of the best paper, the best presenter, and also public information.
Baik, Bapak Ibu, kami beritahukan bahwa coffee break telah kami sediakan di depan pintu masuk dari ballroom ini. Silakan Bapak Ibu dapat menikmati sajian dari coffee break. Dan Bapak Ibu silahkan nanti langsung mengikuti parallel session sesuai dengan ruangan yang telah ditentukan. Dan kami akan kembali di sini, kita akan berkumpul kembali di sini pada pukul 9 malam nanti untuk menyaksikan bersama the best paper, the best presenter, dan juga public information. Baik Bapak Ibu yang ingin membeli oleh-oleh khas Purwokerto juga dapat mengunjungi UMKM yang berada di depan ballroom. Di sana tersedia klanting, sale goreng, keripik belut, dan lain-lain dari UMKM Toko Kedung Jati. Selain itu ada juga koleksi batik dari Batik Jiwarna untuk oleh-oleh yang bisa Bapak Ibu beli untuk dibawa pulang ke kota tercinta.
We also inform to all participants who need some health assistants. There is also a team of health workers from RS Emmanuel Yakum Banjarnegara. To those who need help in terms of like any health issues, you can be accompanied by the committee and can actually see the health workers outside of the ballroom. Thank you very much.
Ya Bapak Ibu, kami sampaikan bahwa ada pos kesehatan di lantai 3, bisa cek gula darah dan juga tensi. Partisipasi rumah sakit dari Emmanuel Banjarnegara bagi peserta ICOLGAS. Kami ucapkan terima kasih juga kepada Bapak Ibu yang telah hadir secara online, seluruh Kepala Kejaksaan Tinggi seluruh Indonesia dan juga jajarannya, juga Kepala Kejaksaan Negeri beserta dengan jajarannya yang berada di seluruh Indonesia. Terima kasih atas kehadirannya. Baik Bapak Ibu, kami ingatkan kembali Bapak Ibu silahkan menikmati hidangan coffee break dan silahkan Bapak Ibu bergabung di masing-masing ruangan untuk melaksanakan parallel session. Dan silahkan nanti kembali ke ballroom pada pukul 8:30 malam.
Pemirsa, kegiatan internasional Conference on Law, Governance and Social Justice Fakultas Hukum Universitas Jenderal Soedirman yang dimulai dari nyanyian Indonesia Raya hingga pengisian dari pembicara-pembicara luar biasa yang dibagi menjadi 2 sesi dengan diskusi tanya jawab. Terima kasih pemirsa sudah mengikuti International Conference on Law, Governance and Social Justice Fakultas Hukum Universitas Jenderal Soedirman. Saya Pita Septiana dan tim kru yang bertugas undur diri. Terima kasih, sampai jumpa. Alright, ladies and gentlemen, this is closing for the international conference, which started from singing Indonesia Raya and filled by amazing speakers with Q&A discussion. Thank you for joining the third ICOLGAS International Conference on Law, Governance and Social Justice Faculty of Law, Jenderal Soedirman University on October 4, 2023. Pita Septiana and all crew BMSTV, see you on the next program.